We begin our study of federal court jurisdiction by focusing on subject matter jurisdiction, often abbreviated as SMJ. Subject matter jurisdiction is the fundamental power of a court to hear the specific type of case that has been brought before it. It answers the question, does this court have the authority to rule on this particular dispute? This concept must be sharply contrasted with personal jurisdiction, or PJ. Personal jurisdiction concerns the court's power over the parties involved in the lawsuit, ensuring fairness to the defendant regarding where they can be sued. While parties can often consent to or waive arguments regarding personal jurisdiction, subject matter jurisdiction is entirely different. This means that if a federal court lacks subject matter jurisdiction, it cannot proceed, even if both parties agree to let the case continue. The court must raise this issue on its own motion at any stage of the proceeding. For federal courts, SMJ is the essential gateway. Without it, the courthouse door remains locked. Since subject matter jurisdiction is the essential, non-waivable gateway, we must now examine what grants a federal court the authority to hear a case. Remember, federal courts are courts of limited jurisdiction. Unlike state courts, which generally have broad jurisdiction, federal courts can only hear cases specifically authorized by the Constitution and Congress. This authorization flows primarily from Article 3 of the Constitution, which Congress has implemented through specific statutes. There are two primary statutory paths that open the federal courthouse door. The first path is federal question jurisdiction, codified in Title 28, Section 1331. The second path is diversity jurisdiction, found in Title 28, Section 1332. In the following lessons, we will explore each of these two pathways in detail, starting with federal question jurisdiction. We now turn our focus to the first pathway, federal question jurisdiction, governed by Title 28, Section 1331. This statute grants federal courts jurisdiction over any civil action arising under the Constitution, laws, or treaties of the United States. The critical phrase here is arising under, which triggers the core test for federal question jurisdiction. For jurisdiction to exist, the federal issue must be a necessary and substantial element of the plaintiff's cause of action. This requirement is strictly enforced through what is known as the well-pleaded complaint rule. In essence, the federal question must appear on the face of the plaintiff's initial complaint when properly pleaded. This covers claims directly based on the United States Constitution, federal statutes, or international treaties ratified by the United States. If the federal issue is merely tangential or arises only as a potential defense, jurisdiction under Section 1331 will not be established. The well-pleaded complaint rule demands strict adherence. Jurisdiction is not established simply because the defendant might raise a federal defense. For instance, if the plaintiff sues for breach of contract under state law, and the defendant plans to argue that the contract violates a federal statute as their defense, federal question jurisdiction does not automatically attach. The federal issue must be part of the plaintiff's affirmative case. Similarly, an anticipated federal counterclaim by the plaintiff is insufficient to create jurisdiction. Even if a state law claim requires interpreting or applying a federal standard, such as determining compliance with a federal regulation, this alone usually does not confer jurisdiction unless the interpretation of that federal standard is an essential, necessary element of the state law claim itself. The focus remains squarely on what the plaintiff must prove to win on their initial complaint, as dictated by the relevant state law cause of action. Now that we have thoroughly examined federal question jurisdiction and the strictures of the well-pleaded complaint rule, we transition to the second primary pathway for federal subject matter jurisdiction, diversity jurisdiction, codified in Title 28, Section 1332 of the United States Code. Diversity jurisdiction grants federal courts the authority to adjudicate disputes that primarily involve state law, provided the litigants themselves are sufficiently separated by geography or citizenship. However, unlike federal question jurisdiction, which focuses on the substance of the claim, diversity jurisdiction imposes two strict, mandatory requirements that must both be satisfied simultaneously for the court to proceed. First, the parties must meet the standard of complete diversity of citizenship. Second, the amount in controversy asserted by the plaintiff must exceed $75,000, exclusive of interest and costs. We will explore each of these pillars in detail in the subsequent segments. We now turn our attention to the first mandatory pillar of diversity jurisdiction, complete diversity of citizenship. This requirement demands that no plaintiff shares the same citizenship as any defendant. To determine citizenship, we must first define it for the parties involved. For an individual person, citizenship is defined as their domicile at the exact moment the lawsuit is filed. Domicile means the place where a person lives with the present intent to remain indefinitely. For a corporation, the rule is twofold. A corporation is a citizen of both its state of incorporation and the state where it maintains its principal place of business, often referred to as its nerve center. Now, the crucial element is complete. This means if you have Plaintiff 1, Plaintiff 2, Defendant 1, and Defendant 2, every single plaintiff must be diverse from every single defendant. If even one plaintiff shares citizenship with even one defendant, for example, Plaintiff 1 is a citizen of Texas, and Defendant 2 is also a citizen of Texas, the entire basis for diversity jurisdiction collapses immediately, and the federal court must dismiss the case for lack of subject matter jurisdiction. Having satisfied the requirement of complete diversity of citizenship, we must now satisfy the second mandatory pillar for diversity jurisdiction, the amount in controversy, or AIC. Under Title 28 United States Code Section 1332, the amount in controversy must exceed $75,000. It is vital to remember that this threshold is calculated exclusive of interest and court costs. Now, let us address aggregation, which determines how we count claims toward this threshold. If a single plaintiff has multiple, separate claims against one defendant, those claims can be aggregated to meet the $75,000 minimum. However, the rule changes when multiple plaintiffs are involved. Generally, multiple plaintiffs cannot aggregate their separate claims against a single defendant to reach the threshold. The exception to this rule is when the plaintiffs share a common and undivided interest in the recovery, such as in a suit for partition of property or a true class action. Now that we have covered the two core requirements, complete diversity and the $75,000 amount in controversy, we must address specific nuances within diversity jurisdiction. Under Section 1332. First, consider alienage jurisdiction. This allows federal courts to hear cases where the dispute is between United States citizens and aliens, or between two aliens themselves. This is an extension of diversity jurisdiction. However, even if both diversity and the amount in controversy are met, Congress has carved out specific statutory exceptions where diversity jurisdiction is explicitly barred. These exceptions apply regardless of how diverse the parties are or how large the claim is. Key examples tested on the Uniform Bar Examination include matters of domestic relations, such as divorce, child custody, and alimony. Additionally, probate matters, concerning the administration of wills and estates, are also excluded from federal diversity jurisdiction. These limitations ensure federal courts do not intrude upon traditional state court competencies. We have now thoroughly examined both pathways to federal subject matter jurisdiction. To conclude, let us synthesize the core differences between federal question jurisdiction and diversity jurisdiction. The fundamental distinction lies in what aspect of the case grants the federal court authority. For federal question jurisdiction, the focus is entirely on the nature of the claim itself. Does the well-pleaded complaint necessarily raise a substantial question of federal law? In contrast, diversity jurisdiction is entirely concerned with the parties involved and the amount in controversy. We require complete diversity of citizenship and a claim exceeding $75,000. It is crucial to remember that these same jurisdictional standards, federal question and diversity, are the exact tests applied when determining whether a case properly removed from state court must remain in federal court. Ultimately, federal courts are courts of limited jurisdiction. If your case fails to satisfy the requirements for federal question jurisdiction, and simultaneously fails to meet all the strict requirements for diversity jurisdiction, then the federal court must dismiss the case for lack of subject matter jurisdiction. This is the final gatekeeper for federal court access.